So Adam was in the courtroom today. That's one of his superpowers, his competitive advantage of all those legal pundits out there is that he actually goes into the court and was there for 92-year-old, the diminutive Alvin Hellerstein, who fresh off of handling the Maduro indictment, the next thing on the docket was the case of Donald Trump and the new people of the state of New York, as Donald Trump tries for the second time to get the same federal judge to allow him to take his now conviction and sentencing on 34 felony counts of business record fraud and election interference related to Stormy Daniels, related to the $130,000 payoff through Michael Cohen, statements made by him after he got to the White House, to cover up the conspiracy. And it's still kicking around because Donald Trump has a fantasy that he's going to get to a federal court and magically, because of the immunity decision at the United States Supreme Court that happened about 10 days before he was sentenced, that he's going to be able to convince a federal judge that he was just punching the federal officer clock, just doing his job when he did the conspiracy to cover up his sex acts with Stormy Daniels. And there's a federal defense, because if he doesn't have those two things, he's done and he's dead. He's toast. So this big hearing came together because the Second Circuit Court of Appeals back at Brown Thanksgiving agreed with Trump's lawyers on one issue, that Judge Hellerstein didn't give appropriate weight, or wasn't asked to at the time, to the immunity decision, and whether that changes his analysis under the federal officer removal statute or not. Okay, you're in the courtroom. Tell us everything that happened.
Well, the biggest takeaway is that Trump is going to lose this round.
Okay, good night, everybody.
I usually refrain from making predictions like that.
I don't.
This is a nearly 3-hour hearing.
Yeah.
And Judge Hellerstein did not play the cards close to the vest. This was something where he took the arguments into 3 parts, and in all 3 parts, he really let Trump's attorney have it. And it was his private attorney from Sullivan and Cromwell. And let's just take a step back, because you laid out the stakes really well, Michael, but I want to make sure that it's clear that this is something that Trump has been trying to erase the blot of the 34 felony convictions, even though there's no prison sentencing, even though there's no real consequence for that. He is trying to mount an attack. And let me just set the stakes for this, that if he won on this, and he seems fated to lose. But even if he won on this, the consequence of this is that he'd have a slightly quicker appeal. It would go to a federal court and then immediately go to the Second Circuit and then the Supreme Court. If he loses, and it appears he's going to lose, Judge Hellerstein said at one point, when the lawyers were trying to convince him that his arguments weren't waived, said, "It looks like we're beating a dead horse here." My theory is your decision, the particular litigation decision that they made, was, quote, fatal to the case that this belongs in federal court. So what's next? He has a pending appeal already in state court. In New York, it's the Appellate Division, First Department. That's the Intermediate Court of Appeals. It's already underway. And if the Supreme Court upholds the underlying conviction, it goes to the highest court in New York, which is the Court of Appeals. And then the Supreme Court can review this. Now, why are we here to begin with? After Trump was convicted of 34 counts of falsifying business records for the purpose of influencing the 2016 presidential election, and that was the stakes here, and that was the rebuke by a unanimous jury. Once that happened, in very shortly after, we have the immunity decision from the Supreme Court. And though it was generally a 6-3 decision, 5 of the judges went so far as to say immunity is also an evidentiary rule. If there is an official act, that if there's evidence that derives from an official act, you can't use it. And Trump's attack is essentially Prosecutors shouldn't have called Hope Hicks, who was my employee. They shouldn't have called Madeleine Westerhout, who was also working for the White House, the Oval Office, Director of Operations. Hope Hicks's testimony in particular was wrenching. She was crying on the witness stand as she was using the she said that she knew Trump was essentially lying to her when she talked about when Trump said, Michael Cohen gave the money out of the goodness of his heart.
Let
This wasn't trying to disguise this from the voting
let me
public.
jump in for 1 minute. Let me jump
Yeah.
in. Trump, to put it in layman terms, Trump's position is that even though the conspiracy involving David Pecker of the National Enquirer, nobody ever had a better name,
Mhm.
Michael Cohen, Donald Trump, Alan Weisselberg, the money people, even though that conspiracy to pay off Stormy Daniels, to buy her story for the National Enquirer, kill the story so she didn't go to the press, so there wouldn't be an October surprise during the election with against Hillary Clinton. Even though that entire conspiracy was completed before he was president of the United States, because there were some loose ends that happened after he won the presidency that he had to deal with, like the reporters asking questions about his fitness to be a president and payments to Michael Cohen, which is just the tail end of it, because he talked to Hope Hicks, that somehow converted his private affair, to use Alvin Hellerstein's words, his private affair into a official presidential conduct. And because Madeleine Westerhout runs his front desk and was his gatekeeper for scheduling, this somehow creates, in the eyes of the Supreme Court, presidential immunity over a dirty conspiracy about a sex act.
And
Right? That's
it
sort of
goes
it,
even
right?
further than that because what the Supreme Court carved out a rule, they made it an evidentiary rule. They said not only is immunity something that attaches to an official act over an underlying conspiracy, you cannot use evidence that relates to an official act. And this conspiracy, and I was at every day of the trial, I reported on the trial every single day. And the theory was, and what the jury found, is that conspiracy extended through a significant part of Trump's first presidency. And they showed Trump's tweets, and Trump is arguing, hey, my tweets, to lie to the general public about the affair with Stormy
Lying.
Daniels,
Right.
that is itself an official act. You shouldn't have shown the tweets. You shouldn't
Ugh.
have called people who were staffers in my White House.
Now, to the credit of the Manhattan DA, they didn't have the benefit of the immunity decision when they were putting on their case, because the
Right.
immunity decision happened after the conviction. So you can't fault them for like going all in and bringing in Hope Hicks and bringing in Michael Cohen and this and that, because they didn't know that the Supreme Court was not only, as you just so perfectly put, not only found immunity for official conduct or core constitutional conduct, but also made this effed up evidentiary thing. You can't even use the evidence of an act to convict him. Now, there was a pile of evidence here. Donald Trump, if you ran that trial 1,000 times and you took out Hope Hicks's testimony and her crying, he would have been convicted 1,000 times in a row. Okay, so that's. But listen, any port in a storm for Donald Trump. Oh, and the Second Circuit, I don't want to say they bought it, but they were like, you know what? Let's send it back to Hellerstein, who was 90 when he made the original decision. He's 92 now. Let's let him, with the immunity decision benefit, let's let him decide it. But that's not where the most of the hearing went, right? The
Right.
hearing went to the timeline and the fundamental question, and you were in the room, so you tell me, but what I can see, the fundamental question for Hellerstein was, let me get this straight. You made a litigation decision that when you got the immunity decision from the United States Supreme Court, by the way, same lawyers, Todd Blanche, Emil Bovee, John Sauer, arguing, when you got it, okay, you didn't file a paragraph notice of removal to take the case back to federal court based on it. You kept going back to Judge Merchan. You kept asking him to have it impact the conviction or impact the sentencing, right? And you
Right.
took 4 months to come back to federal court. You waved. You
And
waited
yeah,
to see
exactly.
Merchan. You waited for the two bites of the apple, right? You waited to see what Merchan would do. Oh shit, he didn't help us out. Now let's try to go to federal court.
Right. And that's exactly what Judge Hellerstein said. It said that it's a second bite of the apple. It said that that is fatal. That was the word that he used, fatal, to their case. And that was the main issue. Issue number one, a waiver. Issue number two was another legal principle that is the case even removable? There is nothing left for me to do, Judge Hellerstein said over and
Right.
over again.
Right, you're
The
convicted.
judgment is entered. He, insofar as he would just not disturb the judgment and make it his judgment, he said that he's reluctant to do that as a federal judge. What? I haven't reviewed this. I can't sign my name to this. And so there was a separate question, question number two, of is this thing removable to federal court when there's nothing left for him to do other than send it up one more tier of appellate review? The third question is the substantive question. Does immunity apply? So I'll be very interested in seeing how he rules. I think it is very clear, based on 3 hours of oral arguments, that he is not going to send Trump a ruling that he's going
How
to be pleased with.
how do this is the stuff we don't pick up other than in your reporting like yours. We're watching federal judges, especially in the criminal context, civil too, under attack. They're being abused. They're not being respected. They're being disrespected in a way. I mean, I've been practicing for 35 years. I mean, other than yes, Your Honor, and no, Your Honor. I had, it'll go up. I think it went up today. Michael Ludig, the Fourth Circuit Court of Appeals judge, who's really a champion for justice and the Constitution, on with Lisa Graves and me today. And at the end of talking about things, I just reflexively called him Your Honor, even though he's a retired judge, because, that's what's baked into my DNA. How did these lawyers from Sullivan and Cromwell, who don't work for the Department of Justice, but work for Donald Trump, how did they treat Hellerstein? Because I heard it was like hot and they were going back and forth. So tell me about it.
Well, I think they were frustrated with the tenor of they saw that this was a losing proposition and they tried to. I wouldn't say, look, I sat through the criminal cases and the civil cases. There was some very disrespectful lawyering toward the judges in these cases. This one was passionate because
Mhm.
they saw that they had a hot bench, but this wasn't, I would say, pugilistic toward
We're,
Hellerstein. I
we're,
think that Hellerstein will be able to see some angry tweets when this is all over. But
All right,
but
so,
so
well, let
far
me
as
ask you. Let
what
me ask you.
transpired.
Were they frustrated because they did not anticipate, based on the Second Circuit remand back to Hellerstein, which did not mention the temporal, the "you're too late" part? Did they think that the judge should only be focusing on the application of the immunity decision to the facts to determine whether federal officer color of federal office prong have been satisfied, and they were caught flat-footed because they didn't think he was going to get into, based on the way the case came back from the Second Circuit, the issue of "you're late" by a lot? Was there any of that?
I think that they just thought they had more winning arguments. They
Mm.
trotted out a bunch of circuit precedents that weren't Second Circuit precedents on the issue of waiver, and that it was a low standard. That there's a colorable argument that there was a reason, a good cause to bring this case to federal court. I think that the lawyer passionately felt, oh, we didn't waive it because look, sentencing was 10 days away, and that, what would we have done? We could
Both. You
be
do both things.
disrespectful to Justice Merchan, who they were disrespectful to throughout the trial. But it was this sort of thing. I think they were surprised that their arguments were such losing arguments
Well,
before Judge.
let me ask you this. They sounds like they never had a coherent response to the question, why didn't you do both? Why didn't you go to Merchan and file the notice of removal, which would have stopped all action in the state court by the mere filing of the notice of removal? And the second thing I want to know, did they cite and could they cite one case anywhere where post conviction and post-sentencing, by another 4 months, a federal officer ran in to take the case to federal court after everything was done and dusted. Did they have one case?
I think that's where Judge Hellerstein, where the rubber hit the road. They said that you're giving me these citations. These citations are in civil cases. He
Right.
gave them a lot of civil cases where the judgment had been over, but there was post trial briefing, and they said that it shouldn't matter. But Judge Hellerstein didn't buy that. He looked at the federal removal statute. He interrogated good cause. Like, look, there's been a lot written about Judge Hellerstein being a 92-year-old judge. And, if there are questions about his sharpness on the bench that were raised in the context of Maduro's prosecution, seeing him in action, he put Trump's lawyers on his toes. And I'm going to just give a little bit of context, a little bit of background. I know that you've spoken about it,
Yeah.
Michael, about Judge Hellerstein. He has been uh, one of the bravest judges when it comes to government overreach. He shot down the Trump administration's claims in the Alien Enemies Act case. He was the one who found a First Amendment violation in trying to send Michael Cohen to prison after he was going to write his book, that he thought it was retaliatory, that he had COVID era release and they were sending him back just because he was writing a book. Before that, he was the one who put forward the release of the Abu Ghraib videos. And so he's a judge who has always held the government to task when warranted. And even at the ripe old age of 92, he's doing it for 3 hours.
I love Hellerstein for so many reasons. First of all, he reminds me of my own grandfather. My grandfather was in his 90s. He ran a business until the very end. In fact, I'll just tell one anecdote. I know where you need to wrap up soon, but just to show that I definitely don't have natural instincts not to trust a 92-year-old just because of their age. My grandfather was in the hospital, but he had a business to run. We owned and he ran for since 1906 with my family, a soda and seltzer and beer distribution company in New Jersey. And I was like 18 or 19. So I went to the hospital with my father and we had a clipboard and we were getting notes from my grandfather about the customers and the route that I needed to handle while my granddad was in the hospital. And the nurse came in and said, "Who are you guys? What are you, his accountants?" And we said, "No, we're his son and his grandson, and we're talking business. Get out of here." So, he had the tubes and the whole thing. So this does not surprise me that somebody, Joe Flom, who ran my old law firm, was well into his late 80s handling major merger and acquisitions for corporations.
Right.
Yes, we have examples in recent history of people under the strain of the presidency that don't look to be quite with it on both sides of the aisle, but that's not Alvin Hellerstein. When do you think he's going to issue that decision?
It's hard to say. I don't think that there's any question in his mind about what the ruling will be, but the details of the ruling might take some time to iron out. And I agree with you, Michael. Every time I've seen Hellerstein in court, he has seemed sharp as a knife to me.
Yeah.
He has put all parties, and not only the government, on their toes. He's very, his questions are fastballs over the plate from that bench.
Yeah. Yeah. So really fantastic. So we'll get together later in the week. Just tell our audience before you leave, what other stories are you following on All Rise News? And while everybody's here, hit the subscribe button for All Rise News. That pays the bills. Become a paid subscriber for Adam. That gets him into the courtrooms all around the country. He was on his way to Tennessee for the Abrego Garcia before the snowstorm. I mean, this is what keeps the resources flowing. Same here on Legal AF. I'm running a 35% sale on our paid subscribers right now in honor of all this stuff. So make sure you do that. And then you'll get this video also as a regular member in about, I don't know, an hour on Substack, because we've been going for about 20 minutes or so. But tell our audience what you're following at All Rise News for this week.
So this week, I'm following the fact that a federal judge has rejected Elon Musk's attempt to evade deposition. He's going to be called to the hot seat in the Doge litigation. I'm going to be covering next week. The plan is to cover Don Lemon's scheduled hearing in Minneapolis. As you noted, I covered the news where it happens. And that happens because of All Rise News subscribers allow me to go across the country when there's a major hearing breaking some.
Don's out, right? He'll self-surrender, and he's not in detention.
Oh, no, no,
Yeah,
no,
yeah,
no, and he already had, he's
yeah.
released on his own
Yeah,
recognizance.
right,
There was
right.
another hearing in an LA court. This is
Got it.
the initial conference
All
in
right.
Minneapolis.
All right, great. You're gonna go?
That's the plan,
Oh,
that's the plan. The reason I only put little caveat there because 2 hearings were canceled
yeah, I
recently.
know.
Kilmar Abrego Garcia, if it's not canceled, I'm gonna be there on the ground.
Yeah. Yeah, great, great. Oversight hearings going on in the halls of Congress about ICE and all of that. I've got
Yeah.
Senator Blumenthal on with me tomorrow. That'll be up tomorrow on Legal AF. Judge Ludig on today on Legal AF YouTube channel on a great interview. Wait till you see what he has to say about federal judges and their courage and the United States Supreme Court. He does not hold back. I've known Ludig now for 3 or 4 years. He was on a roll today. You can't miss that interview. It's up there. And we'll be back, 2 lives a day here on Legal AF YouTube channel. All right, Adam, why don't you, I'll stay for another couple of minutes with the audience, and then we'll catch up with each other this week.
Sounds good. Great
Adam
chatting.
Glassfeld, All Rise News.
Thank you.